Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with an update in the case of Robert Sylvester Kelly, also known as R. Kelly. If you haven't done so already, check out my video that I posted last night on the people that were pardoned by Donald Trump. It is a long video, it's about 2 hours long, but if you go into the description field underneath the video, I do have some time markers that show what topics of what person I'm talking about throughout the video and what time period. And I do talk a little bit explaining why R. Kelly did not become a candidate for pardon in the list of people that Donald Trump pardoned. So go ahead and check that out. And I've dropped the link above. So Mike Leonard, who is leading the New York defense in Mr. Kelly's case, has submitted a letter to Judge Ann Dunley, who's overseeing the case, regarding the prosecution's refusal to submit discovery information. And so he wrote in the letter, "Dear Judge Dunley, we respectfully submit this letter on Mr. Kelly's behalf as a motion to compel, seeking this court to immediately require the government to produce discovery materials to Mr. Kelly and his counsel, including but not limited to 3,500 and gigolo materials." I keep saying gigolo throughout this video, but I'm sure it's pronounced gigolo, as in some Italian person who probably contested the federal government withholding discovery in their case. So 3,500 and gigolo materials refer to the Brady rule, which states that the prosecution must submit discovery to the defense in a timely manner to allow them to prepare for the case. And it also deals with information that the government has secured that could basically be in favor of the defendant, and in this case R. Kelly. And so here's a little information. It's referred to impeachment information, and it says that impeachment information which depends on the prosecutor's decision on who is or may be called as a government witness will typically be disclosed at a reasonable time before trial to allow the trial to proceed efficiently. In some cases, however, a prosecutor may have to balance the goals of early disclosure against other significant interests, such as witness security and national security, and may conclude that it is not appropriate to provide early disclosure. In such cases, required disclosures may be made at a time and in a manner consistent with the policy embodied in the Jinx Act, which is part of the United States Code 18-3500. And I believe that it is 60 days that they can submit that information 60 days prior to trial. And then there was a piece on training. It says all new federal prosecutors assigned to criminal matters and cases shall complete within 12 months of employment designated training through the Office of Legal Education on Brady, gigolo, and general disclosure obligations and policies. All federal prosecutors assigned to criminal matters and cases shall annually complete 2 hours of training on the government's disclosure obligations and policies. This annual training shall be provided by the Office of Legal Education or alternatively any United States Attorney's Office or Department of Justice component. Now, all of these prosecutors have been prosecutors for a while, so there is no reason why they don't understand their obligations to submit this information. And in another piece, it says the discovery obligations of federal prosecutors are generally established by federal rules of criminal procedure 16 and 26.2 of the Jinx Act, Brady versus Maryland. And it says that the United States manual describes the department's policy for disclosure of exculpatory and impeachment information in order to meet discovery obligations in a given case. Federal prosecutors must be familiar with these authorities and with the judicial interpretations and local rules that discuss or address the application of these authorities to particular facts. So it is spelled out clearly what their obligation is to fulfill their role in submitting this information, but yet here we are still not getting the information. So the letter goes on to say, in short, this court urged the government during at least one of the parties' status hearings to both cooperate with defense counsel and to produce all discovery materials sufficiently in advance of trial to allow Mr. Kelly and his counsel an adequate opportunity to prepare for trial and to avoid needless delays in the trial and or the continuance of the trial. It was Mr. Kelly's counsel's understanding that the government would produce all such materials 90 days prior to trial. That time has come and gone. This is simply no reason for the government to continue to withhold these important discovery materials, which are undeniably crucial to Mr. Kelly and his counsel's trial preparation and to Mr. Kelly's defense and constitutional rights. Moreover, the government possesses the materials and has the ability to produce them immediately. The only reason that these materials are being withheld is to allow the government to gain a tactical advantage and as gamesmanship. The action is decidedly not one that should be based upon trial by surprise or trial by only an opportunity for one side to meaningfully prepare. All of this might be different if the government had not already had all or the bulk of these materials in its possession for years or at least many months. And so Mike Leonard seems to be tired of them, like we're tired of them also. So the letter goes on to say the pandemic will make it even more difficult for Mr. Kelly's counsel to take investigatory and other steps once they finally receive these materials. That is exacerbated by the fact that the allegations in this case stem from events that are allegedly to have occurred literally decades ago, and by the fact that at some point Mr. Kelly will be inaccessible while he is being relocated to Brooklyn for trial. The notion that the government would ever agree to or be forced to proceed to trial under these circumstances is absurd. In any event, to date, the government has only offered to produce the, quote, first, end quote, batch of phase of these discovery materials, but only to produce those materials on February 5th. The government has not offered any explanation whatsoever as to why all of the materials can't be produced immediately, nor has the government offered any timeline for the production of the additional materials. So they're saying that on February 5th, they will provide the first batch of information, but they're not going to provide all of the information. So Mr. Kelly's counsel has attempted by way of emails and otherwise to meet and confer with the government to amicably resolve these issues to no avail. However, a partial and non-quantified production of some of the discovery materials approximately 2 weeks from now would not resolve these issues. For all of those reasons, the court should grant the motion to compel and order the government to immediately produce all discovery materials to Mr. Kelly's counsel and for such other and further relief as is appropriate under these circumstances. Sincerely, Mike Leonard. Now, you guys might remember, I can't even remember what I was talking about in this particular video. It might have been one of the Don Russell videos that I did. And you guys remember Don Russell was supposed to have been entering in plea negotiations back at the end of October. And then we didn't hear anything else about these plea negotiations. But Don Russell has a hearing coming up. I believe it is February 4th or 5th, where I guess we'll hear more about these plea negotiations. But on all the other cases, there was a letter, there was a ruling that came out with the government back in November that talked about this Brady rule. And once again, reminding these judges that before every hearing that they are supposed to advise these prosecutors the rules about turning over discovery. And I noted in whatever that video was that on everybody's records, there is a copy of that letter being sent to them. So on Don Russell, the Richard Williams, the Michael, whatever his name is, guy that, was charged with setting the car on fire. So on all of their records, and even in the Northern District of Illinois cases, they all have this letter attached to their document history in PACER talking about this Brady rule. But I noticed that on R. Kelly's record, the judge didn't send that letter. And so I'm wondering if now the prosecutors are going to come up and say, oh, well, we didn't get that letter. But let me go ahead and read it to you guys, what it says. So this letter was sent to Don Russell from Ann Dunley, and it says, Ann Dunley, United States District Judge. This order is entered pursuant to Federal Rule of Criminal Procedure F5F to confirm the prosecution's disclosure obligations under Brady versus Maryland, 373 U.S. 83, 1963, and its progeny, and to summarize the possible consequences of violating these obligations. The prosecution must disclose to the defense all information favorable to an accused, that is, material either to guilt or to punishment, and that is known to the prosecution. The obligation applies regardless of whether the information would itself constitute admissible evidence. The prosecution shall disclose such information to the defense promptly after its existence, because known to the prosecution promptly after its existence becomes known to the prosecution, so that the defense may make effective use of information in the preparation of its case. The prosecution must also disclose any information that can be used to impeach the trial testimony of a prosecution witness within the meaning of Gigolo versus United States, 405 U.S. 150, 1972, and its progeny. Such information must be disclosed sufficiently in advance of trial for the defendant to make effective use of it at trial or at such other time as the court may order. The foregoing obligations are continuing ones and apply to materials that become known to the prosecution in the future. These obligations also apply to information that is otherwise subject to disclosure, regardless of whether the prosecution credits it. In the event the prosecution believes that a disclosure under the order would compromise witness safety, victim rights, national security, a sensitive law enforcement technique, or any other substantial government interest, it may apply to the court for a modification of its obligations, which may include camera review or withholding or subjecting to a protective order all or part of the information otherwise subject to disclosure. For purposes of this order, the prosecution has an affirmative obligation to seek all information subject to disclosure under the order from all current or former federal, state, and local prosecutors, law enforcement officers, and other officers who have participated in the prosecution or investigation that led to the prosecution of the offense or offenses which the defendant is charged. If the prosecution fails to comply with this order, the court, in addition to ordering prosecution of information, may 1. Specify the terms and conditions of such production, 2. Grant a continuance, 3. Impose evidentiary sanctions, 4. Impose sanctions on any lawyer for the prosecution responsible for violations of the prosecution's disclosure obligations, 5. Dismiss charges before trial or vacate a conviction after trial or a guilty plea or 6, enter any other order that is just under the circumstances. And this is so ordered by Ann Donnelly on November 16, 2020 in Brooklyn, New York. So it's very clear what they were supposed to do, why they are still playing games. I haven't seen any motions being filed, that would apply to the exceptions that's listed here, that it would somehow compromise a law enforcement officer or their investigation techniques. None of that has been filed. So there really is no reason why they haven't turned over this information. Once the prosecution responds, and I'm sure they will, I will let you guys know what their response is. So just want to bring you this update to the case. We'll probably start getting more videos from me on this topic as we move closer to trial. And then, as I mentioned earlier, in the letter from Mike Leonard, they are preparing to transfer him to Brooklyn ahead of the trial. So I expect that probably will take place in March or maybe late February, but I'll keep you guys posted as more information is made available. So that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.